Good afternoon. Thank you so much for the opportunity to testify here today about a topic which is related to one of the EEOC's top priorities, which is eliminating barriers in recruitment and hiring. In April of 2012, the Equal Employment Opportunity Commission updated its guidance document titled Consideration of Arrest and Conviction Records in Employment Decisions under Title VII. That document is available on the EEOC's website, which is www.eeoc.gov. This document consolidated and superseded EEOC guidance documents from 1987 and 1990. It contains the same legal positions with more thorough analysis than was contained in those earlier documents. The question you might ask is, why was it necessary to update these documents? Well, criminal information is much more widely available now than it was then at the time those documents were written. Anybody can get it on the internet. There are loads of private companies in the business of providing information to companies on criminal background. Most employers now do criminal background checks for some or for all jobs. They have good reasons to do so. They want to avoid exposure to liability for negligent hiring. They want to reduce the risk of violence in the workplace, the risk of theft, the risk of fraud. There are some federal laws which require background checks and exclusions. There are some state laws which require background checks and exclusions. The problem is that national data supports a finding that criminal record exclusions have a disparate impact on race and national origin. While the 2010 census shows that 72.4% of the United States population is white, 16.3% of the population is Hispanic, and 12% of the population, 12.6% of the population is African American, a 2010 Pew study finds that with respect to incarceration of 18 to 64-year-old men, 1 in 87 is a white male, 1 in 36 is Hispanic, and 1 in 12 is African American. In addition, ex-offenders are one of the fastest growing segments of the United States population. In 1980, 170,000 individuals were released from prison. In 2009, over 720,000 individuals were released. In 2004, more than 14 million individuals in the United States had felony convictions. Assuming incarceration rates remain unchanged, about 1 in 17 white males are expected to have some prison time in their lives, to serve some prison time in their lives. 1 in 6 Hispanic men, and 1 in 3 African American men. President Obama says America is facing an incarceration and post-incarceration crisis. And to make matters worse, the criminal record information that employers sometimes rely on to exclude individuals often doesn't reflect criminal convictions. It may show a stop and frisk, it may show a criminal citation, an arrest, a deferred prosecution, a criminal charge filed, a criminal charge dropped, a court warrant. None of these show a conviction, but often result in the exclusion of the individual from employment. The EEOC's longstanding approach is, number 1, the fact of an arrest does not establish that criminal conduct occurred. Arrest records are not probative of criminal conduct. Second, convictions are considered to be reliable evidence that the underlying criminal conduct occurred. As I said earlier, national data supports the finding that criminal record exclusions have a disparate impact on race and national origin. A policy or practice that excludes everyone with a criminal record must be job-related and consistent with business necessity in order not to violate Title VII. It's important for me to note at this point that the updated EEOC guidance, which I referenced, does not prohibit employers from using and obtaining and using background reports about job applicants or employees. The EEOC doesn't have this authority. The new guidance seeks to ensure the information is not used in a discriminatory way. And there are 2 ways for employers to use the information discriminatorily. Title VII of the Civil Rights Act of 1964 prohibits employers from treating job applicants or employees with the same criminal records differently because of their race, their national origin, or another protected characteristic. This is classic disparate treatment discrimination. The law also prohibits disparate impact discrimination. So if the criminal record exclusions operate to disproportionately exclude people of a particular race or national origin, the employer has to show that the exclusions are job-related and consistent with business necessity to avoid liability under Title VII. Job-related and justified by business necessity requires the employer who is using a screen to show that it considers the nature of the crime, the time elapsed since the criminal conduct occurred, the nature of the specific job in question, and that it gives the applicant an opportunity to show why he or she should not be excluded. This is called a targeted screen. These requirements have come from litigation on the issue over the course of time, specifically the Green versus Missouri Pacific Railroad case from 1977 and L versus Southeast Pennsylvania Transportation Authority, a 2000 case from the Third Circuit. I'd like to conclude with some best practices which are contained in the guidance. They're suggested for employers. First, employers should eliminate across-the-board policies which exclude people from employment based on any criminal record. Second, employers should develop a narrowly tailored written policy and procedure for screening applicants and employees for criminal conduct. Employers should train their managers, their hiring officials, their decision makers on how to implement their policies and practice consistent with Title VII. Employers should limit the inquiry to criminal records which would be job-related for the position in question and consistent with business necessity. I have been encouraged recently to see that some employers are using these best practices as they make their hiring decisions by using targeted screens. And the result is the best balance between employers' legitimate concerns and the requirement of non-discrimination contained in Title VII. Thank you.